I'm going to talk a little bit about the role of marriage and family therapist in divorce-related legal issues in the state where I practice, which is Ohio. There are two general states of divorce that you can apply for in the state of Ohio. One is general divorce and the other is disillusionment of a marriage. Divorce in the state of Ohio is fairly easy. There's no fault and fault divorce. The divorce for a general divorce is fairly easy, but the practitioner must take into account whether or not the petitioner or the party who files for divorce has been a resident of the state of Ohio for at least 6 months, and then a resident of the county for at least 90 days. This can be difficult if the individual is married in the state of Ohio but then moves away or was not originally a resident of the state of Ohio. So that may cause some problems for individuals who are petitioning for a divorce, especially a general divorce. The disillusionment of marriage, each individual is a co-petitioner, so both individuals must meet the same requirements for residency of both the state and the county, and they both need to have their own representation. They must sign a petition for a disillusionment of marriage and a separation agreement. This usually helps to settle property and debt, alimony, child support, and custody. So it's a legal document that has been drawn up by both parties and their legal representatives and approved by a judge for the disillusionment of the marriage. Both general divorce and disillusionment are filed in the Court of Common Pleas. That means that there is a court hearing, that the judge makes sure that all the paperwork is in order, and he asks some questions of both parties, and then enters a decree of either disillusionment of marriage, or at that point it can be upgraded to just a general divorce. So they can be used interchangeably, to the extent that if you start with a disillusionment, you can upgrade to a general divorce if the judge feels like a general divorce is more appropriate than a disillusionment. There is a collaborative family law process that helps to work with individuals that are divorcing in the state of Ohio. They work towards a settlement in matters of dispute. Each party must have their own family lawyer and negotiation process. So they like to use marriage and family therapists independently of anyone who has been seeing anyone from the family come in and help mediate some of those collaborative family law processes. With the no fault and fault-based grounds, there are some general things that are included in a fault divorce, which include bigamy, willful absence of the other party for 1 year, adultery, extreme cruelty, fraudulent contract, gross neglect of duty, habitual drunkenness, and imprisonment in a state penitentiary. However, there are exemptions for that, and they all require proof, which makes the no-fault divorce more popular as a choice. However, with disputes that involve child custody, we see more and more of the at fault, especially citing violence and drug and alcohol use. Most of the time in these court proceedings, an MFT is used as a mediator or to conduct external evaluations, which means that a person who has never seen individuals from the family at any point come in to do assessments on individuals through interview and or the children through interview, having not performed any psychotherapy. With child custody, the judge makes most all the decisions in matters regarding the child's best interest, because the state of Ohio is one that uses the standard of whatever is in the child's best interest. Some of the things that he takes into consideration or she takes into consideration are a lot like what we would take into consideration as a marriage and family therapist doing the assessment, such as the wishes of the parties and what their goals are for the disillusionment or the divorce, or the child's goals, as in who they want to live with, why, and what are some of the things that are going on inside the household. The child's relationship with the parties, the siblings, and any other significant other persons in their life, whether or not they've had good relationships or not. The child's adjustment to home, school, and community, the mental health, physical health of all persons involved, and the party is more likely to honor and facilitate parenting time rights. So the one parent side who seems to be more amicable about being there and following the rules that the court has set forth is more likely going to be the one that the court looks at for sole custody. The court also looks specifically at whether or not either party has failed to make a child support payment or if they're in arrears, whether each party or a household member was a perpetrator of a child abuse or neglect or a violent or sexually oriented offense involving the member of a family specifically, and whether either party has continuously or willfully denied the other party's right to parenting time in accordance with the order of the contract, which means if either one of them have decided not to participate in following the rules set forth by the court. They do participate in shared parenting, and that is a collaborative effort that the marriage and family therapist who has been contracted solely to help with these processes and not do psychotherapy with the individuals would be to look at the ability of the parties to cooperate and make decisions jointly. That would be part of their evaluation process. Each party's ability to encourage contact between the child and the other party, positive contact. Any history of or potential for child abuse, domestic violence, or parental kidnapping needs to be evaluated. And the geographic proximity of the parties to one another. Is it feasible for them to move back and forth between each parent? The recommendations of any guardian ad litem for the child needs to be taken into consideration, because they're going to be the MFT who's been contracted's legal representation as well for the child, because the state takes into consideration the child's desires, welfare, needs above both parties. Taking into consideration that the state of Ohio is a best interest of the child standard, we as marriage and family therapists and the judges involved, they conduct interview for collateral information, and the judge usually appoints the professionals that do this. They are not chosen by the family on either part, and they're chosen by the court system so that they can be impartial. Especially if a divorce is hotly contested or a relationship is particularly volatile, however, the court may not feel it has enough objective information to make its custody decision based solely on the interviews of the parents. In this case, the court may order a custody evaluation, and that's when the professionals would be brought in to do that. According to the AA-MFT ethics, there are several rules that we need to take a look at and look at specifically for this particular situation. First is specifically informed consent. So if you are being asked to, through either subpoena or by a client, to testify on their behalf and in court, One of the things that you need to really look at is whether or not you have rightfully looked at how to prepare the patient for that, giving them the good and the bad consequences and reviewing that record with them and letting them know just exactly what it is that they are agreeing to have released. So we have to look at the capacity of the consent. Are you dealing with a minor, or are you dealing with the parents? Have they been adequately informed of the information concerning treatment process and procedures, which is standard for most practices now? That they've been adequately informed of the potential risks and benefits of the treatments and disclosure of the treatments for which their generally recognized standards do not yet exist. Especially with what's going on in the world today, we have to look at things such as telemedicine and telehealth as a part of that, as well as having group counseling sessions or group family counseling sessions where you maybe ask about other people who have participated and were not necessarily a part of the therapy process. We have to look at relationships with third parties because the court may request that you do this, and marriage and family therapists have to agree with the ethics code 1.13, relationships with third parties, that agreeing to provide services to a person or entity at the request of a third party, you must clarify the extent that is feasible at the onset of services, the nature of the relationship with each party, and the limits of your confidentiality. Basically saying, yes, we've been required to do this by the court system, and that all of the information that we gather can be admissible in court. We also have to look at 7.7, separation of custody evaluations from therapy, that we avoid conflict. This is specifically if you have been working with a family or family members, and whether or not you've had any past experience, especially with psychotherapy with the individuals. In the state of Ohio, with being appointed, we don't have to look at this as much because we should be telling the court ahead of time if there's been a conflict of interest that would preclude us from being able to do those kinds of services. We also have to take a look at 7.8, which is professional opinions. We can't provide a professional opinion without seeing the person face to face or having that meeting one-on-one. Finally, there are a couple of things you can do if you have received a subpoena, especially to be in compliant with the APA, MFT rules of conduct and ethics. You must have a release of information. You have to check with the client and not the attorney. You have to discuss the issues with the client before releasing the records. You have to comply with the specific requirements of the subpoena, meaning, especially with the new HIPAA requirements, that only releasing the relevant and minimum necessary information, which is consistent with the new HIPAA regulations, minimum necessary requirements of information. You can consult with an attorney and an ethics representative. Usually, insurance companies for malpractice provide this service to help keep you and them from paying out for problems with legal issues. In the state of Ohio, they want you to check if the subpoena is valid or if it's been considered insufficient to compel a testimony. This happens specifically with individuals who are subpoenaing from different states. Since we border several states, if you've been subpoenaed from, say, West Virginia to Ohio, it may not be considered a valid subpoena because you as the witness are a resident of Ohio and you practice in the state of Ohio and you follow Ohio rules and regulations. Therefore, a subpoena from West Virginia may not be enough to compel you to do testimony. You must always provide some kind of response to a subpoena. HIPAA regulations require therapists to restrict the disclosure of confidential information to a minimum amount of information needed. So keep it simple. And remember that in the state of Ohio, what is in the best interest of the child is what everyone is looking for.